Hello and welcome to the Target UPSC series of Drishti IAS, and this particular series is dedicated to the Prelims 2025. And as you already know that we had initiated this particular series for your Prelims examination. So in this series today we are going to talk about the polity. We already had done one episode on polity, so if you have not watched that episode, do check that. In this session we are going to discuss various important topics related to the polity which can be asked in your prelims examination. So do read it very carefully because this is a kind of revision series and there are chances that might be question can be asked from this session. So let's start our discussion. So here is our first news. Supreme Court upholds secular socialist in preamble of the Constitution. So here we have to understand that what is the news. So we have to know to the nitties-gritties of this particular thing. As you already know that this is our preamble, and in the preamble we have this word sovereign socialist secular democratic republic. So here we have to see that what Supreme Court has to say about this thing. Socialist and secular, Supreme Court has upheld the inclusion of the word socialist and secular in the preamble through the 42nd Constitutional Amendment Act 1976. Under Article 368, Parliament can amend provisions of the Constitution including the preamble. The right to freedom of religion, Article 25 and 28 provides the right and liberty to preach, practice and propagate the religion of his or her choice. So here what we have to understand that why secularism is important for any country. So in India we do have a different kind of secularism. It means that state believes in equality. It means that state does not discriminate with anybody if anybody is following any different religion. So in the eyes of state, all the religion are equal, and if people have freedom to follow their religion. So state has no religion, but state is not away from the religion. So this is a Indian concept of the secularism which we have. So here India's unique interpretation where the state respect all religions. Then here if you'll see about Article 14, 15 and 16 of the Constitution prohibit discrimination against citizens on religious grounds. So we do have various articles. We have freedom of religion, we have this right to equality. So all these what articles and constitution provisions says that we believe in equality. We believe that if anybody wants to profess their different religion, they all have right to do that. And Article 44 also talks about the Uniform Civil Code. It is not restricted by the term secular in the preamble. And if we'll talk about the socialism, so in order to boost the social and economic opportunity, the word socialism has been inserted into the preamble of India, and socialism practiced in India aims to achieve the goal of economic and social upliftment of the citizens. In the comment section you have to tell me that is preamble a part of Constitution of India or not, and it does not restrict private entrepreneurship and right to do business, which is guaranteed as a fundamental right under Article 19(1)(g) of the Indian Constitution. So this is about the sovereignty, socialism, secularism, democratic. So this is very much important thing which Indian Constitution have, and that makes our society very much equal. Then if we'll talk about the secular civil code, so PM Modi calls for a new secular civil code. So we already had discussed about the secularism and socialism. Now here we are going to talk about the secular civil code and what it is. So here if we'll talk about that, in his speech, Independence Day speech, Prime Minister had talked about the secular civil code instead of uniform civil code, but its essence is uniform civil code. So as you already know that various states has implemented uniform civil code including Uttarakhand. So what is uniform civil code? So uniform civil code refers to a set of laws that govern personal matters like marriage, divorce, adoption, inheritance and succession for all citizens in India. And the concept of UCC is mentioned in Article 44 of the Indian Constitution as a directive principle. So it has been mentioned as a directive principle. It means that it is not enforceable. It's up to the state that whether they are enforcing or not, but it is not legally enforceable that you have to say that you have to apply and you have to implement Uniform Civil Code. So this is the status of the Uniform Civil Code, which PM Modi has called secular civil code. Then we'll talk about the landmark judgment related to the UCC. Shah Bano case, the court noted with the regret that Article 44 has remained a dead letter and advocated for its implementation. So right now also we see a lot of debate related to the implementation of Uniform Civil Code in Uttarakhand. Also we can see that there were a lot of debates, but right now it has been not implemented officially in India. Then Shaira Bano case, the Supreme Court ruled that the practice of triple talaq was unconstitutional and violated the dignity and equality of the Muslim women. It also suggested that Parliament should pass legislation to regulate Muslim marriages and divorces. So these all things which are relating to the personal life, married life, divorce, so these all are part of the Uniform Civil Code. Now we'll talk about the World Bank working paper advocates increased devolution for panchayats. So as you already know that panchayats are backbone of the Indian political system. So here we are going to talk about that what World Bank is suggesting about the Indian panchayats. So if we'll talk, here we can see that a paper of the World Bank, 250,000 democracies, a review of village government in India, has called for granting greater authority to panchayats. So here the panchayat, they have this suggestion that panchayat should become more powerful and more active while strengthening local fiscal capacity to ensure effective local governance. So we do have Panchayati Raj institution in India that refers to the system of the rural local governance in India, and 73rd constitutional amendment gave it a constitutional status. So constitutional status to Panchayati Raj and assigned them the task of the rural development. So here it is about the Panchayati Raj institution. So we already had discussed about the 73rd constitutional amendment and what it provides. So it provides a established structure, uniform structure, elections, promotion, and what you can say inclusion of the SC, ST and women. Also provision for the transfer of the funds, functions and functionaries to PRIs, and the act mandated a 3-tier system of the local governance. One would be, the initial would be the village Gram Panchayat, intermediate block panchayat and district Zila Panchayat. So these are the decentralized form of the Panchayati Raj institution. So here if we'll talk about the provisions, so Article 243G empowers state legislature to delegate powers to panchayats for the financial empowerment of panchayats. Provisions have been made in terms of the Article 243H and Article 243I of the Constitution. Article 243H gives state legislature the power to authorize panchayat to levy, collect and appropriate taxes, duties, tolls and fees. Article 243(1) mandates the formation of the State Finance Commission. So all these articles are related, which says that the panchayat do have powers in India and they do have certain functions in India. All World Bank has to say that they need to be more effective and more stronger. So here if we'll talk about the related initiatives, then we have one initiative which is Swamitva scheme. Survey of villages and mapping with improvised technology in village areas scheme was launched on National Panchayati Raj Day 2020 to enable economic progress of rural India by providing record of right to every rural household owner. E-Gram Swaraj or E-Financial Management System. E-Gram Swaraj is a simplified work-based accounting application for panchayats. Then we have this geotagging of assets. The Ministry of Panchayati Raj has developed ActionSoft, a mobile-based solution to help in capturing photo with geotags, GPS coordinated for the works which have assets as an output. Then we have one citizen charter in order to focus on the commitment of the PRIs towards its citizen in respect standard of services. Here it had provided a platform to upload citizen charter documents with slogan Meri Panchayat Mera Adhikar, Jan Sevaएं Hamare Dwar. So all these schemes are related to the development, effective functioning of the panchayat, and it also shows that how there should be the digital inclusion and digitally aware of the panchayat. So here you can connect to the functionaries directly through the digital medium. Then we'll talk about the Bihar's call for the special category status explained. So as you already know that when there was this Lok Sabha election result and JDU got its 12 seats, so there are so many speculations that JDU is helping BJP because Nitish Kumar, who is current chief minister of Bihar, wanted from the BJP that there should be a special status given to the Bihar. So that marks a very curious thing about that what is the special status category and which states have got it. So we'll talk about it. So what is special category status? So it is a classification granted by the central government to states that are geographically and socio-economically backward to provide financial assistance for their development, and they does not have any constitutional provision. It means that they are not mandated by the constitution. Such provisions have been introduced in 1969 based on the recommendation of the Fifth Finance Commission, and status was first accorded to Jammu and Kashmir, Assam, Nagaland in 1969. Telangana is the newest addition to this special category status. So there are so many debates that Bihar should be also given the special category status. Let's see that whether these states are eligible to take special category status or not. Hilly terrain should be there. So in Bihar we do not have hilly terrain. It is a plain low population density. We have high population density, sizable share of tribal population. So when there was not undivided Bihar, there was sizable share of the tribal population, but right now all those population went to the Jharkhand. Then strategic location along borders with neighboring countries. Yes, Bihar share a border with Nepal. Economic and infrastructure backwardness. Yes, this thing is with Bihar. And non-viable nature of state finances. This is also with the Bihar. So these all things sparks a debate that if Bihar is meeting the criteria, then why Bihar is not given this particular status. Well, we'll know in future that what is happening with the Bihar. So here, what are the benefits one special category status state gets? The center pays 90% of the funds required in a centrally sponsored scheme to special category status states as 60%, 75% in the case of other states. So here 90% will be given to the what you can say bear by the government. Then unspent money in a financial year does not lapse, so it can be reused and it can be used for the other purpose also. Significant concessions are provided to these states in terms of the excise and custom duties. 30% of the center's gross budget goes to the special category status. So this is the thing. Then what are the powers of the speaker and why is the post crucial for the BJP and its allies? So this time also so many people have debated over that Om Birla should not be appointed as speaker again and again. But if we are talking about the constitutional provision, that do constitution have this power that Om Birla can appointed again and again? Yes, constitution has no bars that one person cannot be appointed twice or thrice as a speaker. So here we'll discuss on to that. So what is the speaker? So speaker is a constitutional and ceremonial head of the house, and each house of the parliament has its own presiding officer. So in Rajya Sabha we have chairperson and deputy chairperson. In Lok Sabha we have speaker and deputy speaker. So here in the comment section you have to tell me that who is the speaker of the Lok Sabha and who is the chairman and chairperson of the Rajya Sabha. So these are the origins. So in 1921 Government Act of 1919, under the name of President and Deputy President, this provision has came. But in 1935 it has been changed and it has been called as a Speaker and Deputy Speaker. So election both Speaker and Deputy Speaker, Article 93 and Part 5 talks about it. There should be a simple majority. Re-election they are eligible. Then election criteria should be member of Lok Sabha. No specific qualification, generally belong to the ruling political party. Tenure generally 5 years till immediate before first meeting of the next LS. So one of the biggest power speaker has is to decide on the money bills, also disqualification of the Lok Sabha members. So these are the very much important power speaker has. So here final interpreter of the constitutional provision in Lok Sabha, her ruling are binding in nature, presides over a joint sitting of the two houses of the parliament, can adjourn the house, suspend the meeting in absence of quorum, power of casting vote to resolve a deadlock. He or she will decide that whether one bill is a money bill or not. disqualification of the members, removal condition if he or she ceases to be a member of the Lok Sabha, written resignation to deputy speaker removed by effective majority. So these are the terms and provisions related to the speaker. Then we have one thing which is pro tem speaker, and this time also the appointment of pro tem speaker was very much debatable and controversial. So first of all, we should know that what is pro tem speaker. So when there is a election and when there is a declaration of result, so till the appointment of next speaker, there will be one pro tem speaker, and that pro tem speaker will observe the oath and affirmation of the people. So that person is called as pro tem speaker. Usually the senior most members of the house is given this particular status. So this is called as a pro tem speaker. So the president administered the oath of the speaker pro tem. So here we have this thing. Then we are going to talk about the Delhi LG allows Arundhati Roy to be prosecuted under UAPA in 2010 case. So here is the picture of the Arundhati Roy. She is a scholar, she is a what you can say great writer. So why she has been charged under UAPA, we are not going into that, but we are going to discuss about the UAPA and other things related to it. So here Unlawful Activities Prevention Act. On 17 June 1966, the President promulgated the Unlawful Activities Prevention Ordinances to provide for the more effective prevention of unlawful activities of individuals and association. Subsequently, the Unlawful Activities Act of 1967 was enacted to provide for more effective prevention of certain unlawful activities of individuals and association for dealing with terrorist activities and for matters connected therewith. So unlawful activities are defined as actions supporting or inciting the cessation of any part of India. So if there will be breach on the sovereignty, integrity of the country, and if any person or if any organization is talking about the secession of the India, if there will be breach on security, then those activities will be termed and will be designated under the UAPA, and if any person is provoking such thing, the person will be also designated under the UAPA or charged under the UAPA. So this is that thing. And the National Investigation Agency is empowered by the UAPA to investigate and prosecute cases nationwide. It underwent multiple amendments 2004, 2008, 2012 and 2019, expanding provisions related to terrorist financing, cyber terrorism and individual designation. Though this UAPA was also very much debatable because many of the activists have been charged, and it is debated and it is written in the mainstream media that many were intentionally charged under UAPA, but our main job is to know that what are the provisions related to the UAPA. So till the year 2004, unlawful activities refer to the actions related to the cession and secession of the territory. So after this thing, what we can see that this has been amended in 2019, and right now any individual can be also designated as terrorist under the UAPA. So this is the provisions related to the UAPA. Then India saw 84 internet shutdowns in 2024, more than any other democracy report. So when Trump was announcing the reciprocal tariff, in that reason the Trump has also stated that why we are imposing tariff on India, because of the massive shutdowns are happening in India and that impacts the trade. So here we'll discuss about why there were so many shutdowns in India. So a 2024 report by digital rights group Access Now revealed a record high number of global internet shutdowns. A total of 296 internet shutdowns were recorded worldwide in 2024, the highest ever. Myanmar 85, India and Pakistan 21, and they all accounted 64% of all recorded shutdowns in 2024. So here you can see that India is also among top 3, and India alone accounted 28% of the global shutdown. So here Manipur had the highest, as you already know that Manipur is in a lot of controversy because of the ethnic war and ethnic kind of situation, ethnic conflict is there between the Kuki Methi community. So because of that, we can see here is that Manipur has witnessed the highest number of the shutdowns. Then 16 states and union territory faced internet restriction in 2024. Main reasons are protest, communal violence and exam security. Internet shutdowns in India are governed by the Telecommunication Temporary Suspension of the Services Rules 2024 issued under the Telecommunication Act 2023, which regulates the process of suspending telecom services including the internet. So here it also comes to a picture that whether these internet shutdowns are democratically viable or not. So internet provides you also freedom of speech and expression, and if there will be the shutdown, then it violates your freedom of speech and expression. But government gives such kind of clarification that in order to avoid cheating, such kind of initiatives have been taken in and around the exam centers. So that's why they take such decision in order to protect the integrity and security of the nation. They take such things in order to reduce the nature of the violence, reduce the effects of the violence. The Indian government takes such steps. Now it comes to a very debatable thing that do we have another options to tackle such problem? So this is also one of the thing. Now we are going to talk about the violation of rights. As I have already told you that freedom of speech and expression, article 19, then also right to internet access recognized under article 21, right to life and personal liberty. Then why such things are happening, we had already discussed, because it lacks oversight. There is a lack of strict independent oversight mechanism, and we have not found out a very strong and viable solution for that, and that's why we can see that multiple number of internet shutdowns in India. So here we'll talk about the can the government acquire any private property if it wants. Read the historic decision of the Supreme Court. So here it is a very tricky and interesting thing. So the Supreme Court in the Property Owners Association versus State of Maharashtra case 2024 set limits on the government's power to take over privately owned resources for the public distribution. The petitioners argue that private properties cannot be taken over by the state under the garb of the constitutional scheme of articles 39B and 31C of the constitution. So this has been said by the Supreme Court that the state cannot behave absolute when it comes to the private property, and they said that if they want to protect for the humanity, for the social work, for the state functioning, if they are acquiring the private property, this is not their sole and absolute right. So here we'll talk some facts related to it. So resources vital to community well-being can be acquired by the state, not all private properties. So there are few properties, there are few resources that can be acquired by the state for the well-being, for the welfare of the people, but not all the private properties. This has been clarified by the Supreme Court. Public trust doctrine, that state holds certain resources in trust for the public. Qualification test, a resource must be both material and serve the community, assessed case by case. Materiality refers to the impact of assets like land, minerals, water on economic, social and environmental factors. The court overturned the 1982 Sanjeev Coke ruling, which had upheld the argument that all private property could be deemed material resources of the community. So this can't be done, and state cannot take it as it is. So private community resources, so in which way we can declare any resources as what you can say state acquired resources, and how we can acquire the private property. So these are the 5 ways we have: nationalization, acquisition, operation of the law, purchase by state, and donation by the owner. Then what article 39B talks about? So it talks about that state shall aim to ensure the distribution of material resources to serve the common good. Here, as per the article 31C, article 39B and 39C, it cannot be challenged by invoking the right to equality. It means that state cannot see that in order to promote right to equality and we want to redistribute it, we are taking this property. So there should be other mechanism for that. Now we'll talk about the right to property. So article 31, the original article 31, a fundamental right, dealt with the right to property, but it was repealed and replaced by the article 300A. Right now it is a constitutional right, and this question has been also asked various times. So right to property is a constitutional right, not a fundamental right. And First Amendment Act 1951, the First Amendment Act 1951 incorporated article 31 and 31B into the constitution along with the 9th schedule. And what is article 31 about? It gave the state competence to acquire property or alter rights in property without it being challenged on the grounds of inconsistency with fundamental rights. So this is about Article 31A. So this is the practice question we have. What was the exact constitutional status of India on 26 January 1950? A democratic republic, a sovereign democratic republic, a sovereign secular democratic republic, a sovereign socialist secular democratic republic. So this is PYQ, which has been already asked in 2021. We already had discussed the provisions of the preamble. I had also asked you this question, that whether preamble is a part of Indian constitution or not. Also, you have to be very careful about the keywords. Here we have studied Article 31, Article 31B, right to property, fundamental rights, directive principle of the state policy, which things are enforceable in nature, what Supreme Court has to say about different kind of judgment. So you have to read it again and again, revise it again and again for your prelims examination. I hope you like this session. If you have any queries related to the session, kindly ask into the comment section. Thank you. Have a nice day.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.